Hello, my name is Ryan Ejim, and I am a student at Osgoode Hall Law School in Ontario. And in this episode of Case Law Minutes, we're going to be taking a look at the Court of Appeal of Alberta case RM and JS. This is a family law case that pertains to the subject of a child's objection to an order to return him to his habitual jurisdiction. Specifically, this case outlines the court's reasoning for rejecting a child's objection and not making the child's objection the sole or predominant factor in deciding to order the return of the child. As a disclaimer, this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. With regard to the Court of Appeal decision, the court allowed the appeal and directed that the child be returned to the custody of his mother forthwith. This entire proceeding began because the mother brought an application after the child's father, who is a Canadian citizen, failed to return his then 9-year-old son, who is also a Canadian citizen and was visiting him in Calgary, to the custodial mother who resides in East Jerusalem. The trial judge found the father's failure to return the child was wrongful, but he gave effect to the child's objection to return to live with his mother in Israel and subsequently refused the application. The mother appealed that decision to the Court of Queen's Bench, but a judge of that court gave deference to the trial court's judge's discretion and denied the mother's appeal. The mother then appealed to the Court of Appeal of Alberta. The Court of Appeal of Alberta allowed the appeal and directed that the child be returned to the custody of his mother. The mother applied for the child's return pursuant to the International Child Abduction Act, which implements the Hague Convention. The following is a list of terms of the convention relevant to this application. The Hague Convention Article 1 clearly sets out the objectives of the present convention: to secure the prompt return of children wrongfully removed to or retained in any contracting state, and to ensure the rights of custody and access under the law of the contracting state are effectively respected in the other contracting states. Article 3 outlines when and where the removal or the retention of a child is to be considered wrongful. Article 4 outlines when the convention shall apply and to who the convention shall apply. It is also important to note that Israel is a contracting state for the purposes of enforcing the convention. Article 12 outlines the promptness of the return of the child unless it is demonstrated that the child has now settled in its new environment. Article 13, which is of particular importance to this case, outlines that the judicial or administrative authority of the requested state is not bound to order the return of the child if the person, institution, or other body which opposes its return establishes that there is a grave risk or that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. It is important to know that the judicial or administrative authority may also refuse to order the return of the child if it finds that the child objects to being returned and has attained an age and degree of maturity at which it is appropriate to take account of its views. In considering the circumstances referred to in this article, the judicial and administrative authorities shall take into account the information related to the social background of the child provided by the central authority or other competent authority of the child's habitual residence. Lastly, Article 20 outlines in what particular situations the return of a child can be refused. These are instances where human rights and fundamental freedoms are involved. In order to understand the reasoning at the Alberta Court of Appeal, it's important to take notice of the decisions that were made in the lower courts. At trial, the judge declined to make an order for the return of the child to East Jerusalem because that judge took into account the views of the child and found that the views had not been coerced by the father. Subsequently, at the Court of Queen's Bench, the mother's appeal was dismissed. The Queen's Bench judge found that the mother had not met the high standard of review required to overcome the trial judge's exercise of discretion. In the Court of Appeal of Alberta, counsel for the mother submitted that there was no proper evidence before the trial judge from which he could conclude that the child was of an age and degree of maturity to object to his return to Israel. And the judge erred in weighing the child's objection and in making it the sole or predominant factor in declining to order the return of the child. On the other hand, counsel for the father submitted that there was evidence before the judge supporting his finding that the child had attained an age and degree of maturity such that it was proper to take the objection into account. Thus, the judge's weighing of that evidence in exercising his discretion is entitled to deference. It's important to note that the issue in this case is not what's in the best interest of the child. That is an issue the contracting states have agreed is best left to be determined by the country in which the child has habitually resident before the move. The issue instead is whether conditions for the return under the Hague Convention have been met. On this subject, the trial judge found that both the failure of the father to return the child was wrongful and the child faced no grave risk if returned to the mother in East Jerusalem. No issue is taken by either party with respect to these findings. The last remaining issue is whether the child was sufficiently mature to express his views on where he ought to live, and if so, what weight to give to those views. In short, should the child's stated objection be permitted to trump all other considerations? With regard to the evidence before the judge hearing the application, it's important to note that the application proceeded on the basis of affidavits brought by both the mother and father's counsel. These affidavits did not address the maturity of the child. The father deposed that when the child arrived in Calgary, he told the father that he wanted to stay in Canada and was scared to go back to Israel. However, no cross-examinations on the affidavits were conducted. The child was also represented by counsel. After asking him a number of prepared questions from a respected child psychologist, the child's counsel made submissions on the issue of the child's maturity and essentially advised the court that they believed the child possessed sufficient degree of maturity that the court should take into the view the account of the child. In the Court of Appeal's view, the submissions of the child's counsel did not provide a proper evidentiary basis for the trial judge to assess the maturity of the child, nor to assess the child's view if he was sufficiently mature to have them considered. The Court of Appeal also found that the issue before the court was first whether the child had attained an age and degree of maturity such that it was appropriate to take his objections into account, and second, if he was sufficiently mature, what weight should be given to his views. On these issues, the submissions of the lawyers did not amount to useful evidence. The Court of Appeal also found that determining the level of maturity of a child is a difficult matter, calling for some expertise. In this particular case, although counsel was well versed in the law, they did not demonstrate that they possessed any specialized expertise in understanding and in analyzing the thoughts of young children. Lastly, the Court of Appeal found that an opinion, whether expert or not, is no better than the facts supporting it, and in this case, there was little, if any, evidence before the trial judge other than the list of questions prepared by the psychologist to support the opinion being offered by counsel. The second difficulty with counsel's evidence on maturity was that it was presented through submission. Ordinarily, counsel cannot give evidence without forsaking his or her position as counsel because the inability to cross-examine on the evidence is a source of considerable prejudice to the other side. The third problem relates to the court's inability to evaluate the child's opinion and where that opinion came from. The fourth difficulty relates to the way in which the trial judge actually weighed the evidence of the child's views. It is clear from the authorities that a number of factors go into the exercise of discretion under Article 13 of the Hague Convention, and that an objection does not result automatically in a decision to reject the application. However, in this case, the trial judge did not explain how he weighed the objections of the then 10-year-old child and why he gave them effect. He seemed to treat the child's objection as controlling. It's important to note, taking account does not mean that those views are always determinative or even presumptively so. In conclusion, deference is not owed to the trial judge in this particular case. In the view of the Alberta Court of Appeal, there was no useful evidence before the trial judge to support the position that the child had attained an age and degree of maturity at which it was appropriate to take into account its views. Thus, the findings made by the trial judge without a proper evidentiary basis constituted an error of law. Furthermore, even if there was sufficient evidence to support the trial judge's views, the trial judge gave an unusual weight to the objections of the child, which ultimately ended up defeating the objects and purpose of the Hague Convention. Now, if you'd like to read this case for yourself, you can find it on CanLee. And of course, if you're interested in more videos like this, or more videos in the series, be sure to check out the litigation channel and subscribe. This is Ryan Ejim, and thanks for watching.